Among all the participants of the arbitration, the arbitral tribunal is vested with the power by the parties and by the arbitration rules to manage the procedure of the arbitration in order to conduct the arbitration in a fair and efficient manner. And within the arbitral tribunal, the chair arbitrator is often the one that acts on behalf of the arbitral tribunal in the management of the entire procedure, such as correspondence with the parties, coordination among the members of the arbitral tribunal, and rendering procedural decisions in the name of the arbitral tribunal. So here we need to stress 2 points. The first one is the arbitral tribunal, they have discretionary power in managing the procedure. And the second is they pursue the values of fairness and efficiency.
When should ADR be used? Well, obviously, ADR should only be used once a dispute has arisen. However, it all begins with the clause. It's very important for parties to include the proper dispute resolution mechanisms in their agreement from the outset. Because once a dispute has arisen, sometimes it's hard for parties to agree on anything, including the way in which it should be resolved. And so preventive dispute resolution begins with setting forth a procedure right from the outset so that when something arises, the parties know what to do. They have guidance. Now, we've spoken about the different modes of a dispute resolution. Are they mutually exclusive? Well, no. Not only are they not mutually exclusive with each other, but you could have, for example, mediation and then litigation in a contract. Internationally, it's usually better to have mediation and then arbitration.
The New York Convention really does 2 things. What's most talked about is the obligation to enforce awards as if they were local court judgments. So if you have an arbitration award that's issued from a seat in Singapore, you can take that arbitration award to any of the dark blue countries and get it enforced. The other piece of the New York Convention, which receives less publicity but is equally important, is all of the signatories to the New York Convention have agreed to have accepted an obligation to stay litigation in their jurisdiction if an arbitration award exists. So if, for example, your contract calls for arbitration in Paris and your counterparty attempts to bring a local court litigation against you in Vietnam, the courts of Vietnam should refuse to accept that case, should stay the litigation pending the outcome of the arbitration in France.